Hey, Stuart.
Okay. Good morning. Judge, are you all set?
I am, yes.
Okay. This is Stu Madison. Welcome to our group this morning. Nice,
Thank you.
sunny day here. Um, I'll go for a bit of an introduction for you. Judge Calabrese will be discussing incapacity, conservatorship, and the probate court this morning. He's been a Connecticut probate judge for 19 years and a practicing attorney since 1995. He regularly presents on probate, estate planning, and other topics at the Bar Association meetings, civics groups, senior centers, which is where I heard about what he can do, and public libraries. So with that brief introduction, I'm sure we're all interested in hearing what he's got to say because it affects what we do, I imagine. And Judge, it's all yours.
Okay, thanks, Stu. I'm just going to pull up my presentation here. Okay. Can everybody see my first slide on incapacity, conservatorships in the probate court? Stu,
Yes.
Is that visible to you?
Yes, we can.
Okay, great. So Stu, thanks very much. And I really appreciate the opportunity to address the Senior Men's Association of Stamford. And as you heard Stu say, I'm a probate judge. I'm also an attorney at law with offices in Stamford and Watertown. I've done hundreds of presentations over the years. I've been a probate judge. And it's important to realize what I'm about to do, what I'm about to tell you today is just for informational purposes. It's not legal advice. At the end of the presentation, I'll be happy to take questions. But the reason why I do these presentations is just to give unbiased information to my audience, to make it less likely that you'll be taken advantage of by unscrupulous purveyors of questionable legal products. By giving you this information, it's my hope that you'll be better equipped to make decisions for your own situation. And that would, in my opinion, require a consultation with a qualified attorney. So what's this presentation going to look like? I have basically 7 items that we're going to review today. I'm going to first talk about what is legal incapacity, the role of the probate court, what a conservatorship is, what a conservatorship does, the kinds of conservatorships we have in Connecticut. And probably most important at the end is, how do you plan for incapacity? The idea behind planning for incapacity is avoiding having to go to the probate court, even if you become incapacitated. So what is legal incapacity? Well, legal incapacity really is defined by Black's Law Dictionary, as you see on this slide. It's the ability to understand the nature and effects of one's acts, a legal qualification, competency, power, or fitness. And of course, incapacity is the lack of those things. So that's kind of our starting point. It's also, it's also important to understand from a legal standpoint that there's different legal standards for capacity depending on the context of the matter. So the list I have here is not an exhaustive list of different legal standards for capacity, but it's really designed to give you an idea that for all of these things, criminal matters, capacity to enter into a contract or execute a will, conservatorships, commitments, guardianships, these all have different legal standards. Capacity is very important with regard to all of these types of legal matters, but the standard is different for each of them. So what are some common causes of legal incapacity? Well, on the left side of this slide, you see certain medical conditions. Again, not an exhaustive list, just to give you some idea. Dementia, see a lot of dementia for sure in the conservatorship proceedings I'm involved in as a judge. Down syndrome, intellectual disability, extended loss of consciousness, somebody who's in a permanent coma or permanent persistent vegetative state. There's also other causes of legal incapacity. Mental illness. The most common cause of legal incapacity in the United States is age. I think we all know that anyone who is under 18 they are essentially incapable by operation of law. Anybody who's under 18 and is involved in legal proceedings, we in our country, in our jurisprudence in the United States, we have to take special precautions to ensure that the rights of someone under 18 are adequately represented, because the law says anyone under 18 does not have legal capacity to advocate for themselves. Other causes are injury or chronic substance abuse. Now, this next slide is something that most people don't really think about: the likelihood of disability. Now, these statistics are not for incapacity, they are for disability. So I have to qualify this by saying all incapacitated persons are disabled, but not all disabled persons are incapacitated. The idea behind this slide is just to convey how likely it is that someone can become disabled or incapacitated. It's 1 in 2 for people who are age 65 or older, and it's almost the same, depending on the individual circumstances, for working age adults. And I would say, even though I don't know those of you in the audience personally, I would say for all of us who are on this webinar, the likelihood that one of us will become incapacitated over the next year is far, far greater than one of us will pass away. Yet, when people think about estate planning, they rarely think about planning for incapacity. They always think about, well, what happens after I pass away? Well, I can tell you, in my probate court, which is one of the 10 busiest in the state of Connecticut, I spend more time in my courtroom on conservatorships than I do on everything else put together. So that's a big number. That's a message I always try to convey in these presentations, because most people think either disability only happens very rarely, or if it does happen, it's not going to happen to them. I can tell you, anybody who's been subject to a conservatorship proceeding in my court didn't think that they were going to be subject to that. So more on this later as we go through the presentation. So what is the role of the Connecticut Probate Court in the context of incapacity and conservatorships? Well, my mentor judge, Judge Robert K. Killian Jr. up in Hartford, he retired recently, but I did an internship at his court when I was in law school many years ago. He said to me, Dom, our role here in the probate court is to protect people's rights, not to protect people. And any court's role is to protect people's rights. But one of the things that happened in Connecticut before our new probate law, before our new conservatorship law was passed several years ago, was there was this idea that conservatorships were designed to help people. And as a result of that philosophy, I think some conservatorship applications were granted in probate courts because of this idea that we're here to help people. Well, we're really not here to help people. And that sounds kind of harsh, but the reality is we're here to protect people's rights. And in a conservatorship proceeding, most conservatorship proceedings, there's an exception, and I'll get into that in a few minutes. In most conservatorship proceedings, someone is dragging you into court. You don't want to be there. And they're saying, Judge, Dom Calabrese is incapable of making decisions for himself. We want you to take his rights away from him and give them to someone else. And as I think you can appreciate when I put it in those terms, that is a very stark, very serious, and potentially very frightening possibility for most people. So why do we have conservatorships in Connecticut? Well, quite simply, the reason for a conservatorship is to make provision for the care of a conserved person's property, person, or both for as long as it might be needed. Now, what are some of the disadvantages of conservatorships? One of the things that's going to be consistent throughout this presentation when I talk about conservatorships and conservators and different ways to avoid conservatorships using estate planning tools is everything has advantages and everything has disadvantages. So the previous slide talked about, well, why do we have a conservatorship? What's the advantage? Well, the advantage is that we can provide for the care of someone or their property if they're incapable of it. So that's very necessary, and it has to be necessary in order for a probate judge to grant an application for conservatorship. But the disadvantages are many, and in my law practice, this is something I frequently talk with my estate planning clients about. Why do you want to avoid a conservatorship? Well, first and foremost, you lose your autonomy. Another person, sometimes a stranger, but it's often a family member, gets your right to make decisions for yourself, and your right is taken away. And that's not a good thing. There's an expense associated with it. What I can tell you is many proceedings in our Connecticut probate courts are designed for people to do without an attorney. They're designed to be quite user-friendly, if you will, but not conservatorships. In a conservatorship proceeding, we operate, we being the Connecticut probate courts, we operate much more like superior court. The rules are very rigid. The proceedings are very rigid. They're recorded, they're on the record. The conserved person has to have an attorney. If they can't afford one, one will be appointed for them. And we have to stick very, very closely to the rules of procedure. So it's a much more formal proceeding than perhaps some others in our Connecticut probate courts. Another disadvantage, and I think this is a significant one, is almost everything that happens in Connecticut probate courts is subject to public disclosure. What are those things? Well, the proceedings themselves are open to the public. But it's not just the proceedings, it's the documents and information that has to be submitted to the court initially and on an ongoing basis for the conservatorship. So if you're subject to a conservatorship in a probate court, it will be open to the public to see how much money do you have? Who are your creditors? What are your expenses? What issues do you have in terms of not being able to care for yourself? These are all very, very personal types of information, and people, understandably so, often feel that this is invasive. But it is necessary, it is what our law states, and it is subject to public disclosure. The only things in a conservatorship that would be protected from public disclosure would be medical documents and tax returns. Everything else is subject to public disclosure. And of course, you have the court involvement. So think about it. You or a family member becomes incapacitated. We know incapacity can strike suddenly and without warning. It's always a stressful situation. If you have to add to that the necessity of going to the probate court, it's certainly going to increase the stress level. So I'm going to talk in a little while about measures that people can take in an estate plan to make it highly unlikely, even if one becomes incapacitated, that they would be subject to a conservatorship. And of course, there's the delay. We like to think our courts, our probate courts in Connecticut operate as efficiently as we can make them, but there is inevitable delay in the process. I'm not going to sugarcoat it and say we do everything nice and quick here. That's not the way it works, unfortunately. And again, if you have a proper estate plan, all the things you see on this page can be avoided. So what are the types of conservatorships we have in Connecticut? Well, there's different ways to categorize conservatorships. So this first slide that I'm showing you here categorizes conservatorships based on who the applicant is. In a voluntary conservatorship, the applicant is the person who's seeking to be conserved. So just to give you an example, many, many years ago, I had a husband and wife come to my court, and they were seeking to have the wife appointed as the husband's conservator. The husband was the one who wanted it, and he explained to me that he was having a major surgical procedure a few weeks down the road, and he wanted his wife to have authority to make medical decisions for him. So in that kind of conservatorship, the applicant, the petitioner, the person who's seeking the conservatorship is the same person who's going to be conserved. So in that case, that person has to have capacity. In a voluntary proceeding, I don't make any finding of incapacity. If I think that person is incapacitated, I will not grant the petition. These types of conservatorship proceedings in Connecticut are exceedingly rare, and I see very, very few of them in my court. The more common one is the involuntary conservatorship. It's the one I described to you a few minutes ago, where you're dragged into court by another person, usually a family member, and that person is saying, we need a conservator appointed for this other person. The respondent, the person for whom the conservatorship is being sought, has to object to the appointment. If that person for whom the conservatorship is sought says, I agree with the conservatorship, I still have to go through the process of an involuntary conservatorship. Although we do have some provisions in our probate proceedings to address that situation, but I don't want to get too technical in this presentation. So suffice it to say that you cannot have someone voluntarily agree to an involuntary conservatorship. Now, the second way to categorize conservatorships in Connecticut is based on the responsibilities of the conservator. There's a conservator of the estate, and I'm going to talk about what those responsibilities might be. There's a conservator of the person, and those are a separate set of potential responsibilities. And then there's something called a temporary conservatorship. I'm not going to talk about temporary conservatorships anymore in this presentation, except to say a temporary conservatorship is only good for 30 days. It's usually used in a situation where the circumstances are quite exigent. And if at least the position of the person requesting the conservatorship has to be such that if it is not granted right away, irreversible harm will befall the conserved person or the conserved person's finances. So let's look at conservatorship of the person. When I talk about the responsibilities that could be granted to any conservator in Connecticut, be aware that our statutes and the interpretation of those statutes by our Connecticut Supreme Court says that the authorities granted to any conservator must be absolutely necessary by clear and convincing evidence, and they have to be the least restrictive means of intervention available. The approach that the probate judges are required to take is to only grant those specific authorities that I just described, and any others that are not granted to the conservator are retained by the conserved person. So these are the potential responsibilities of a conservator of the person. You'll notice as I go through this list, there's nothing having to do with the finances of the conserved person. That's going to be covered in a few minutes under conservator of the estate. So we have general custody of the conserved person, care, comfort, and maintenance, caring for the conserved person's personal effects and personal property. Conservators have to report to the probate court at least annually, unless I require them to report to me more frequently. And the conservator of the person can also establish the conserved person's residence within Connecticut, with the caveat that they can't change the conserved person's residence, even if they have this authority, unless they first come to the probate court and get permission to do it. So other responsibilities that might be granted or could be granted to a conservator of the person is to apply for entitlement programs on behalf of the conserved person. We often get petitions from nursing homes where a resident had been self-pay, but now they need to get on Medicaid, and for a variety of reasons, either because the nursing home can't locate family members, or the family members are not responsive, or the family members are just not able to, we will grant a conservatorship of the person who could apply for entitlement programs like Medicaid, for example, on behalf of the conserved person. This is also another possibility to file an application in the probate court to determine the conserved person's competency to vote. I've never really seen that. It's never really been an issue unless the probate court specifically states that a conserved person cannot vote. They have the ability to vote. And I have never, in all my years as a probate judge, and granted probably thousands of conservatorships, I have never taken away anybody's right to vote. The conservator of the person can also be granted authority to the provision of medical treatment or services or procedures for the conserved person. This is a very common reason why a conservator of the person might be needed, because medical decisions have to be made, and those medical decisions, there's no one to make them. There's no one with legal authority, and the physician or healthcare provider is saying, we need somebody with legal authority to make these decisions. We're not comfortable doing it any other way. Let's look at conservator of the estate. So what authorities might a conservator of the estate have? Well, they could use the conserved person's assets to support the conserved person and any of the conserved person's family members whom the conserved person is legally liable to support. They can also have the authority, and frequently do, get the authority to pay the conserved person's bills, like taxes, for example, using the conserved person's assets. They can also have authority to collect any debts that might be owed to the conserved person. Other authorities, this authority, for example, the sale or mortgage of assets, would require prior probate court approval before the conservator can do it. Conservators, like any other fiduciary, can't do whatever they feel like doing. They can only do what's legally allowed. And that doesn't just apply to conservators. That applies to trustees, that applies to agents under a power of attorney, and that applies to executors of decedents' estates. Here's some examples. Routine payments would be things like you see in the second bullet point: the electric bill, the property taxes, car payments on a vehicle that's already owned by the conserved person, and groceries. Those are examples of routine payments. They do not require coming to the probate court every time it needs to be done. But purchasing an automobile, for example, is not a routine payment. And if the conservator of the estate seeks to do that, they must first come to the probate court for authority to do it. A conservator of the estate has to submit accountings to the probate court at least every 3 years. I may require them more frequently if the circumstances warrant it. And the conservator has to obtain a bond in the amount determined by the court. So the bond protects the conserved person in case the conservator of the estate mismanages the conserved person's assets. So to me, this next section is really the practical part of my presentation. So how do you plan for incapacity, or how do you make it much less likely that you'll be subject to a conservatorship? Well, the objectives in estate planning and planning for incapacity are to increase the likelihood that your wishes will be known and honored, and that you'll continue to manage your affairs even if you become incapacitated. That's really important. It's maintaining control. It's minimizing the need for probate court intervention And really the ultimate objective, in my opinion, of any estate plan is really to minimize the need to get into probate court. And of course, we're talking in the context of incapacity, which in and of itself is a stressful situation. The estate plan that provides for incapacity management of assets and personal affairs will greatly reduce the stress that would result if otherwise court intervention were needed in the case of incapacity. So what are the tools that attorneys use in planning for incapacity? Durable power of attorney, healthcare representative, trusts are incredibly effective means of planning for incapacity, an advanced designation of conservator, an advanced directive, discussion with the family. Notice one thing you don't see on this slide is a will. I've made this presentation over many years, and once in a while I get a question from the audience that says, well, Dom, I have a will. Do I need these other things? And I say, yes, you do. Because a will, and I'm a little dramatic when I say this, but I'm trying to make a point. A will is a useless piece of paper unless and until certain things happen. Number one, the person whose will it is has to pass away. And number two, that will has to be admitted to the probate court. Unless those things happen, that will has no legal authority, and it certainly has no legal utility while the person who has that will is incapacitated. So I'm going to take a look now at all of the items on this list and explain how they work. So we start with the durable power of attorney. The advantages of a durable power of attorney, and in Connecticut with our new uniform power of attorney law, all powers of attorney, including general powers of attorney, are durable. And what does that mean? Well, look at that first bullet point. It remains in effect even during incapacity. Very, very important. Powers of attorney are very flexible. They can be very broad or they can be very narrow. I could grant my brother power of attorney to be my agent in a real estate closing on June 20th in Southbury, Connecticut. It could be that specific. But for the most part, powers of attorney are granted very broad and flexible powers. And again, with our new Uniform Power of Attorney Act, which I think is about 4 years old now, those powers are quite comprehensive and can even include estate planning. Now, what are some of the disadvantages of a power of attorney? Well, a power of attorney is effective as soon as you sign it. Now, it is possible to say this power of attorney is only effective on January 1st, 2022, but I never see that. You can also have what we call a springing power of attorney, which says, well, this power of attorney is effective only if I'm incapacitated. But the problem with a springing power of attorney is in the context of incapacity, now you've got more hoops to jump through. You either have to go to a court and have the person whose power of attorney it is be adjudicated incapable, or you have to have two physicians who are familiar with the principle declare that the person is incapable. And I think some physicians would be very wary of making that type of diagnosis on their own patient. I'm not saying it happens frequently, but it's a possibility. In the wrong hands, a durable power of attorney can create havoc. I have had situations where people would come to my law office. They gave their adult child a power of attorney many years ago. I'm not the one who did it, but now that child is trying to drain their bank accounts. And thankfully, the banks will not honor that power of attorney, so it didn't happen. But just be aware, someone you trust inherently today, will you be able to trust them a few years down the road? That's a very important consideration whenever you're thinking of naming somebody as a fiduciary, including an agent under a power of attorney. So it could get lost. If that power of attorney gets lost, it's useless because you have to show the document to a third party, like a financial institution, in order for it to be honored. The powers granted may be insufficient for unforeseen circumstances. That's always an issue with estate planning. I always tell my clients, I can't make you guarantees. All I can tell you is with this estate plan, it's far more likely that your wishes will be honored than if you didn't have the estate plan. It may not be recognized universally. This is a big issue. In my opinion, this is not black letter law. Once a power of attorney is more than 3 years old, it's far more likely that a third party like a financial institution will refuse to honor it. Why is that? Because the older that document is, the more likely it is that it may not be valid any longer. Now, even though our new Uniform Power of Attorney Act has put provisions to encourage third parties like financial institutions to honor a valid power of attorney, I know that it still occurs. That is, they refuse to honor a valid power of attorney. And healthcare decision-making many, many years ago in Connecticut could have been granted through a power of attorney. It's no longer the case. You need to use a healthcare representative. And I don't know if we have any healthcare professionals on this call, but oftentimes healthcare professionals talk about a healthcare power of attorney. Well, from a legal standpoint in Connecticut, we really don't have that. We have a healthcare representative, and that is a person who can legally be designated to make healthcare decisions on behalf of another person if that person is unable to communicate their wishes to their healthcare providers. So let's talk about the healthcare representative. The advantages are, together with a power of attorney, it may preclude the appointment of a conservator. Every time I get a conservatorship application in my court, there's a couple of questions. Does the respondent, the person for whom the conservatorship is being sought, do they have a power of attorney? And do they have a healthcare representative? Because if they do, I'm going to look at this, and in the hearing, I'm going to say, well, what do you need the conservatorship for? You have the power of attorney, you have the healthcare representative. It allows flexibility in dealing with healthcare professionals who may be reluctant to share medical information with family members due to the HIPAA law. So in my law practice, whenever I put healthcare documents together, I always include a HIPAA waiver so that a healthcare professional who's looking at these documents knows that the person who created them is waiving the confidentiality of confidential information that the healthcare provider would otherwise be forbidden from sharing under HIPAA. The other advantages for a healthcare representative are provision for dealing with medical emergencies if the grantor is incapacitated. And even if a conservator of the person is appointed with healthcare making responsibility, if the healthcare representative is a different person in Connecticut, that healthcare representative can override the conservator, a rather unusual twist to our laws. What are the disadvantages? Well, it may not be recognized by healthcare providers. Just like a power of attorney, a healthcare representative, the healthcare provider could say, I'm not going to recognize this for whatever reason. The other issue is if the person who's designated as the healthcare representative is unwilling or incapable of serving, it has no utility. I have seen more of these fail, and powers of attorney fail too, because only one person is named to be the agent under the power of attorney or the healthcare representative. Our new laws in Connecticut allow for the provision of successor fiduciaries. And I always tell my estate planning clients, you want to name 3 to serve in succession. That makes it a lot less likely that the person or persons you name will be unwilling or unable to serve and then get you into the probate court, which you're trying to avoid. Remember, anybody you name is a fiduciary, trustee, executor, principal under a power of attorney, or healthcare representative. They can refuse to serve, or they can decline to serve any further. So you need a backup in that case, or you're not going to have an effective estate plan. An advanced designation of conservator is a way to communicate with the court that if a conservator is appointed, this is the person you want to serve. It's not saying you want a conservator. It's simply saying if a court decides to appoint a conservator, this is the person you want to serve. And as long as that person is willing and able to serve and there's no objection to their appointment, the court has to appoint them. But remember, this is all about giving you control in different situations, and it's not saying you want a conservator. Only a judge can appoint a conservator in Connecticut. We can appoint our own healthcare representatives, agent under a power of attorney, or trustee, but we cannot appoint our own conservator. Only a judge can do that. Of course, the disadvantage of this advanced designation is just like I talked about for the power of attorney and the healthcare representative. If that person is incapable or unwilling to serve, then the court's going to have to appoint someone else. So that's why you need to name, I suggest, 3 people. So trust, we're going to talk about trust next. And I'm specifically going to talk about the kind of trust that you create while you're alive. They're sometimes called living trusts. If there's any attorneys on the call, you know them as inter vivos trusts. So what are the advantages of trust? Well, of all the things I've talked about today, of all the tools, this is the only one that's effective while you're alive, during your incapacity, and after death. Everything else is only good while you're alive, and after you pass away, their powers terminate. Or, as I mentioned in the case of a will, that's only effective after you pass away and it's admitted to the probate court. The trust is effective in all of those situations. It allows for the management of the assets that are in the trust in the absence or incapacity of the person who creates them. So it's a great tool to provide for potential incapacity, because unlike a power of attorney, you are far less likely to have a problem with a third party honoring your trustee under the trust. It's very effective at avoiding probate administration. Very, very effective, both while you're alive or incapacitated and after you pass away. It reduces probate control over family trusts. It gives you privacy. Trusts are not subject to the jurisdiction of the probate court in Connecticut, except under very specific circumstances. And even those circumstances are very finite in terms of the amount of time the trust is subject to probate jurisdiction. So privacy is important. This is not a public document. It doesn't get recorded anywhere. The public can't see it. They don't know who the beneficiaries are. They don't know who the trustees are or the successor trustees. Once you create and fund your own trust, that trust is invisible. Any assets that are in that trust, the trust for your benefit that you created, you get to use those assets just the same as you would have if they weren't in the trust. Now, again, this is a certain kind of trust. There's certain trusts called irrevocable trusts, trusts that can't be revoked. And this bullet point at the second from the bottom does not apply to those kinds of trusts. But the vast majority of trusts I come across are the revocable living trusts or inter vivos trusts. And trust can also provide protection of trust assets from creditors. And we have a new Uniform Trust Code in Connecticut. It's a little over a year old, and it does allow for domestic asset protection trust, a trust that you create for your benefit that could protect you against your creditors. There's some caveats to that, of course, but that's one of the newest things in Connecticut estate planning law, and it's a very, very comprehensive change in our trust code. Now, what are the disadvantages of trusts? Well, the disadvantages of trusts, and this first one is a big one. I've seen this happen in so many trusts. It's only effective if you transfer assets while you're alive into the trust. I see so many people come into either my law office or the probate court, and they went and had these, what I call one-size-fits-all estate planning trusts put together by these law offices or companies that make the rounds at the senior centers and in the libraries and, you know, in the hotels and so forth. And they put these trusts together and nothing ever gets placed into them. Well, if you don't put anything into your living trust after you create it, you have basically thrown away 80% of the value of that trust. You have to transfer assets into that trust as a separate step after the trust is created. If you don't do that, you've wasted a lot of money, in my opinion. There's also an expense associated in creating and funding the trust. It is subject to a challenge in court. And while a lot of people might think that the lack of probate oversight is an advantage, there are some people who might think it's good to have probate oversight because you have an experienced judge looking out for all the parties, particularly the beneficiaries, to make sure everything's done properly. We have something called advanced directives, also known as a living will. They can cover any aspect of healthcare, including withholding or withdrawal of life support systems. And usually this is coupled with the appointment of a healthcare representative. And there's certain formalities that have to be observed for that advance directive to be effective. The last tool I'm going to talk about with you before I open this up for questions is discussion with family. So you go to your attorney, he creates this or she creates this estate plan for you. But that's not the end of it. You should talk with your family members, particularly with healthcare matters, right? Because what can happen is you can put this healthcare plan together for your incapacity, and it's done very, very properly. But now there's a situation where you're in the hospital, you're intubated, you're on a respirator, and your wishes clearly indicate you don't want that. So your healthcare representative says, Doc, I want you to extubate my husband, my father, my brother, whatever. This is not what he wanted. Well, in that situation, the patient's immediate family member can say, I know that's what Dad wanted, but I don't want you to take the tube out of him. I think he's going to recover from this. And at that point, the healthcare provider is going to say, I know you got this healthcare plan put together, this advance directive and the healthcare representative in place, but you know what? If we extubate this patient and he dies, this family member is going to sue us. So we are not taking that tube out. You just go to the court and you get a court order and then come back and talk with us. So if you talk with your family members about what your wishes are, the hope is maybe, just maybe in the situation I just described, even though that family member does not want you to be extubated, that family member will say, I don't want Dad to be extubated, but he did talk to me about this. And he said this is really what he wanted. So even though I don't agree with it, I'm not going to get in the way of his wishes. So that's the last part of this. And I want to just end this with a word of caution. Planning for incapacity is not a do-it-yourself endeavor. You need to see a qualified attorney who practices primarily in the area of estate planning. Don't use forms online. Heaven forbid, do not use LegalZoom. This is very serious. These are very serious legal documents. And I can tell you, as a probate judge, I have seen absolutely disastrous consequences because people did not go to a qualified attorney to get these documents done. I mean, the things I've seen are just horrible, but it's because people just don't want to go see an attorney. And I understand the hesitancy, but it's a big mistake to do that. So at this point, I'm going to open it up to questions. I think I have about 6 minutes by my clock.
Okay, guys, thank you very much, Judge. That was extremely interesting. I know I have, I think, all those documents that you mentioned. So if you have a question, raise your hand on the system and we'll call on you in order. Then the first person is Carl Shapiro.
I just want to caution guys to always caution, ask a specific question. We don't want rhetoric. We don't want your past experiences. If you have a question, ask a question. Then when your hand goes down, if you have another question, raise your hand again.
Okay, Carl.
Hi, Judge. Thank you for this presentation. I'm actually dealing with a situation on the family side, but the question I have is, have you ever heard of an organization called the Guardian Trust Foundation? And if so, what can you tell me about it, and what services they provide, and when it's time to use something like that?
I'm not familiar with them. I don't know what they do. What I would say to you is if they're involved in putting together any of the documents that I just talked about, and they're not attorneys, if they're attorneys, it's okay. But if they're not attorneys and they're putting these kinds of documents together, I think that's a bad idea. And it's potentially the unlicensed practice of law, but I can't say for sure without knowing more about them.
My understanding is that they're a nonprofit organization that the family might use if, let's say, in this case, the husband, if he outlives his wife who's incapacitated, this organization would take over as the trustee. And is that something you've heard of, or?
I can't say I'm familiar with them.
Okay.
Sorry.
Next up, Lloyd. Oh,
Unmute yourself, Lloyd.
Lloyd.
Oh, we are. Here we go. Mr. Calabrese, I was wondering if I have your permission to take pictures of your slides. If you don't give it, then I'll delete them.
Yeah, I actually, if you want me to send you a PDF of them, I'd be happy to do that. You want me to do that?
Yes, please. Okay.
Judge,
Oh, yeah,
Judge, you have this is Stu. You have my email address. You could send it to me and I can send it to them.
Sure, I'll be happy to do that after the presentation. Sure.
Thank you.
Now, my question is, how often should you review your legally documents like healthcare directives, trusts, and so forth? What do you suggest we do? How often should one do it? I had mine done about 10 years ago. I had it reviewed about 6 years ago. I'm just wondering, what's your thoughts on that?
That's a great question, Lloyd. In my opinion, it should be done no less frequently than every 3 years. So I'll just use your question as an example. You said you had it most recently 6 years ago, right, Lloyd?
Yes.
Well, since then, we have a new Uniform Trust Code, a new Uniform Power of Attorney Act, a new Uniform Directed Trust Act. So the law has changed substantially in Connecticut just in those few years. And I'm willing to bet your personal situation has probably changed a bit as well. So in my opinion, you should see your estate planning attorney no less frequently than every 3 years for those reasons.
Thank you.
Ira? You're mute. Ira, you're mute.
Still muted, Ira.
Ira. Well, while we're waiting for Ira, I have a question, Judge. How do you know does the person get the choice of which probate court to go to?
Sometimes they do. Generally, in Connecticut, the probate court is going to be the one where the decedent was domiciled at the time of death. So that's generally going to be where it is now. If you have a decedent who's a resident of another state, then it's going to be the probate court where the decedent's property was located. Sometimes it could also be the probate court where the executor under the will is domiciled as well. So those are the three most common statutory bases for probate court jurisdictions, and specifically which probate court. But you can't go to any probate court. It's got to be within that statutory criteria.
So if I'm in Stanford, I would go to you or is there a Stanford probate?
There is Judge Gerald Fox is the probate judge in Stamford. So if you are a Stamford resident when you pass away, that would be the probate court that you would go to. And you might know that his father, the late Judge Fox, was the predecessor judge in Stamford who served for quite a long time.
Yeah. Okay. Thank you. Ira, want to give it a shot again?
Yeah. Are living wills and legally and powers of attorney that have been legally established in New York recognized in Connecticut?
Yes, they would be recognized. In Connecticut, our law says as far as those types of documents are concerned, as long as they were executed in accordance of the laws of the state where they were executed, and the person whose documents they were residents of that state at the time, generally Connecticut will honor those. Just remember the points I made about old documents, particularly powers of attorney. But the answer is yes, they would be recognized. There's not a legal need to have them changed if you change your residence, although in my opinion, I think if you change your residence, particularly to another state, even if your estate plan was fairly fresh in the previous state, you probably should still have an attorney in your new home state take a look at what you have.
Thank you.
You're welcome.
Rich Artistic.
Yeah, thank you. I was just wondering if you're familiar with the organization Plan for Connecticut, which I understand is a nonprofit that can serve as a trustee
Yes.
and may be useful, especially perhaps for someone with a disability.
Yes. Yes, I'm actually a member of that group. And yes, they do exactly what you just said. They do pooled trusts for, they're essentially special needs trusts. And a special needs trust is a trust that's set up so that someone who has a recognized disability under the Internal Revenue Code would be eligible to maintain their public or private benefits, but also have the ability to use assets in this kind of trust, the supplemental needs trust, at the same time.
Thank you.
Yeah.
You're welcome.
Okay.
Stu,
Joe-
I have a question.
Go ahead,
I
Joe.
can't raise my hand. As far as the durable power of attorney, and the medical health representatives, typically, assuming that the husband and wife are both capable, they're the designated persons, and contingency would be maybe a child. How important is it for, in either of those two cases, the location of that child or person relative to the name, or the individual?
There's certainly a practical consideration to that. There's no legal limitation on where the fiduciary could live. So you can have somebody who's a Connecticut resident and they can name a fiduciary who's in Hawaii or a fiduciary who's in Japan. But there's practical considerations. I don't think those practical considerations are as compelling as they were many years ago. But it's something at least to think about before you make a decision as to who you're going to name.
That apply more for the health, because some of those decisions have to be made, instantaneously, so to speak.
Yeah, that's certainly a fair point. Although, I mean, in these days, look, we're none of us are together. We're using WebEx or Zoom or whatever this is. So it's a lot easier to do those consultations. So theoretically, if someone was a healthcare representative and they lived far, far away, if they were inclined to be very involved in what was going on, which I think anybody in that position should, they would still have the ability to communicate with the family and the healthcare providers. But I do think there might be some advantage if everything else were equal, that the person who lived closer to the principal, to the grantor, to whomever, might be more advantageous in that role.
Thank you.
You're welcome.
Peter.
Hi. Yes, thank you. My question was, what kind of costs would a husband and wife, be looking at for the basic documents? I understand a trust would probably be more. Could you speak about costs a little bit?
Yeah, I mean, every attorney does these things a little differently in terms of cost. I think what most attorneys do, and this is my practice, is I just have a set price based on what documents you decide you want. So, and I think a lot of attorneys operate that way because you want to know what your cost is as a client up front, as opposed to an hourly fee. So, I mean, it could be, if you just do a basic plan with no trust, I don't know, it could be maybe $3,000. If you do a full plan with everything, with all the bells and whistles, the trust, the wills, all that stuff for a husband and wife, that is for two people, it could be maybe $6,000. It just depends.
That answer your question, Peter?
Yes, thank you.
Judge, I have a question again. You mentioned revocable and irrevocable trust. What's really the difference and why does one pick one over the other?
So a revocable trust, from a tax standpoint, if you have a revocable trust, the tax authorities look at whatever's in that trust as yours. There's no separate tax return that has to be filed. You have full control over those assets. But on the downside, It's not going to be used to qualify for Medicaid. With the exception of our new uniform trust code, you really couldn't use those for asset protection for the person who created the trust, although our new uniform trust code allows that. An irrevocable trust is basically a trust that you don't have control over. You create the trust, someone else is the trustee, or if you're the trustee, there's certain protections built in for other people to exercise certain authorities that you should not exercise. And once you transfer something into that trust, it's no longer yours. It's a gift to the trust. And it requires that the trust have its own tax identification number and frequently file annual income tax returns, depending on what is in that trust and what kind of income it throws off. But it's control. It's control. But if you do an irrevocable trust, it could be an effective asset protection tool against your own creditors, depending on fraudulent transfer laws and that sort of thing. So you can do a lot more with an irrevocable trust, but a lot of people are uncomfortable with the level of control that has to be given up in order to have an irrevocable trust. But I'm oversimplifying it because of the context of the question and where we are today. But those are generally the differences between those two types of trusts.
I guess irrevocable means you can't change it. I mean, once it is,
That's right.
It's in ink. Okay.
That's right. I mean, there's tools you can use to allow some changes, like powers of appointment in a will. But generally, yes, that's true.
Okay. Thank you.
You're welcome.
Any other questions? Last minute questions? Mr. Johnson. You're muted, Mr. Johnson. Bill. Maybe
Bill, unmute yourself.
he
I
did.
just, thank you.
Okay. Judge,
What is the best way to find a good estate planner lawyer? What can you suggest on that?
Yeah, that's a great question. So what I would say is, number one, if you go on my website or my blog, I have an article that I wrote on how to choose an attorney. But let me try to, and it's a fairly short article and it's written for a lay audience, but let me give you some general guidelines. Estate planning, like many other areas of law, has gotten extremely complex. I just told you how our laws in Connecticut changed dramatically over the last couple of years. So my first recommendation is you need to see an attorney who is primarily a trust and estates attorney. An attorney who does car accidents and divorces and criminal law and real estate closings, and they kind of dabble in this stuff. I don't think that's a good idea, even though those attorneys, according to the laws of the state of Connecticut, are qualified to do estate planning. So that's number one. Number two, and this is very important, you need to be comfortable with that attorney. I always tell people you can have the most qualified trust and estates attorney in the world, but if you meet with them and the chemistry is just not there, you're just not comfortable with them, that is not the right attorney for you. The third thing is you need to be sure you know what their fee structure is before you commit to having them do the work for you. And the fourth thing, especially with a bigger law firm, is who is going to do the work on your matter. In a bigger law firm, sometimes they turf off their work to a paralegal or to a junior associate attorney who doesn't have a lot of experience. So the idea is who's going to do the work. So I get a lot of clients who come into my law office who went to some of these big law firms, and they said, after I put my money down, I could never see the name partner anymore. Every time I go into the office, it's a different attorney. Now, I'm not suggesting that that's the case with every large estate planning law firm, but that's been my experience as a practitioner, as an attorney, with people who go to some of these. And I've had clients come to me for some pretty big name law firms, and I've seen that pretty consistently. So those are the basics. If you download my article on my blog or my website, it'll elaborate on that a little bit more, but there should be that comfort level. And like I said, an attorney who dabbles in estate planning, not a good idea in this day and age.
Judge, a question. You're a judge and an attorney in the area. Is that any kind of a conflict of interest?
Yeah, so in Connecticut, probate judges are the only judges who are allowed to have outside employment. So it is not a conflict of interest. What I can't do is, obviously I can't appear as an attorney in my own court, right? I get a lot of jokes about that. And the second thing is I can't do contested matters in any Connecticut probate court. But those are really the only conflicts rules that would be particular to me as a judge. Obviously, all the other conflict rules that apply to attorneys would also apply to me when I'm acting as an attorney. So it's a little bit of a different approach because all the other judges in Connecticut can only do their work as a judge. They can't have outside employment.
Good. Thank you. Okay, I don't see more questions. Judge, thank you so much for spending some time with us, educating us. I'm sure a lot of us are going to look at our documents. I think the issue that Lloyd mentioned about the time to review these things is really important based on everything you said. So again, thanks for your insight. Thanks for the discussion. Thanks for asking our questions and being with us, and have a great day.
Thank you. My pleasure. I appreciate it. If anybody has questions, you can always contact me, give me a call. I'll be happy to answer your questions as well. Thank you, and enjoy the rest of this beautiful day.
Okay, thanks. Joe, yours.
All right, thank you, Judge Calabrese,
You're welcome.
and for very insightful presentation. I think it some of us who thought we were set up now with reviewing it, as Stu said, very important. Again, thank you for being with us today. And as always, guys, stay well, be careful, stay safe, and we will see you next week. Thank you for attending today's meeting.
Bye-bye.
Bye-bye.
Okay.